think I'd like to get us started with providing an overview of some of the basic requirements for executing various estate planning documents and some of the challenges we are facing in meeting those requirements, and then we can turn to some possible solutions. Michael, would you like to start with that one?
Sure. Thanks, Adam. To everybody, I assume you can see the chat box on the side. Oh, who's got an echo going on? Is that me? I thought I had my phone muted. I tried to chat links to the Minnesota Bar Association document that Jolene referenced during her presentation, the one with the links to all the various statutes, and then I also chatted a link to the proposed legislation that hopefully will become law next week sometime. So if that didn't work, let me know. I'll try and figure out another way to get that to you. But in the meantime, we thought maybe we'd just refresh our collective recollections of what the rules are for executing the kind of big four estate planning documents that we're all thinking about for our clients. The first one being wills, trusts, whether they're revocable trusts or irrevocable trusts, powers of attorney, and healthcare directives. So I thought maybe we could just look at those one at a time. So wills, Minnesota law, the Uniform Probate Code, has the requirements for execution of wills under Chapter 524 2-502. So if you are near your computer or you have your statute book at home, you can see from the statute that a will requires a writing. That's one of the most important things. You can't have oral wills. It has to be signed by the testator, or you can have it signed in the testator's name by another person, as long as the testator is in the person's conscious presence and signs at the testator's direction. It can also be signed by the testator's conservator if you have a court order. Unlikely to be done now because the courts are closed. But if you had that order in place, you could use that to sign a will now. And then it has to be signed by at least 2 witnesses. Of course, they have to be adults. They have to be competent. And these witnesses have to sign within a reasonable time of witnessing one of 3 things. They either have to witness the person sign the will, they have to witness the person acknowledge their signature on the will. Yep, that's my signature, even if they signed it previously. Or simply acknowledge the will. Hold up the document and say, this is my will, I've signed it. If you witness any of those 3 things, then, and you're an adult and you're competent, you can sign the will, and that will be a valid will. There have been cases in other jurisdictions where somebody wrote out their will on a tablet with a stylus and signed it in the presence of 2 witnesses who also signed it on the tablet, and that was probated as a will. In other words, the writing, even if it was electronic, that was simply the medium that the person used to write down their will. But they signed it in the traditional fashion. They just didn't use a pen and a piece of paper. They used a tablet and a stylus. So that flavor of an electronic will could work. But Denise will probably, if we can get the sound to work, will talk to us about the Electronic Wills Act and how electronic wills, electronically signed wills, would be different and are currently not permitted under Minnesota law. So many people probably think that when they do a will, they have 2 witnesses and a notary, and in addition to the execution at the end, or what we sometimes call attestation of the will, they'll sign an affidavit. What we call a self-proving affidavit. And Minnesota law has a statute on that. That's not required in order for the will to be valid. It's not required in order for the will to be probated. What it does is it provides evidence of due execution in case there's a contest and you need to prove that the will was signed with testamentary formalities. Under Minnesota's statute, the self-proving affidavit statute is 524.2-504. And one of the advantages of a self-proving affidavit is that it provides conclusive proof that the will was validly executed. In fact, there's a Minnesota case where the person didn't even sign the will. They signed the affidavit, and the witnesses signed the affidavit. and they probated the will, and someone said, well, the will isn't even signed. And the other party said, yes, but with the affidavit attached, it's conclusively presumed to have been validly executed. So we can't even really ask this question about whether it was validly executed. So one tip you might take away from this is if you can get the will signed now in the presence of two witnesses, you could always do a post-execution affidavit later. If you can get the testator and the two witnesses back together, have them sign that affidavit and attach it to the will, now you've got conclusive proof that the will was validly executed. You don't have to have the notary notarize the affidavit right away if that's a challenge. So that would be one solution for wills. Another point to make, if you remember from law school, we used to learn about interested witnesses and how wills should be signed by witnesses who are not interested in the will. That is a good practice, and that certainly was the common law rule, but it is not the rule in Minnesota. The statute in Minnesota specifically says that witnesses are competent to witness even if they're interested. So it's 524.2-505 says the signing of a will by an interested witness does not invalidate the will or any provision of it. So what that would suggest is that if your client is at home, for example, with a spouse and an adult child, they've got enough people to be able to sign the will in the presence of two witnesses. Even though the spouse and the child are beneficiaries and are named in the will, that doesn't invalidate the will or make them ineligible to serve as witnesses. Is that the best practice? Probably not, right? You probably would like to have disinterested witnesses if you could, but we're talking about desperate times, and so if you can at least get two other people to be able to witness the signature or the acknowledgement of the will. So one of the things you might think about is if the person is, say, isolated in a room, they're in a nursing home or they're in a hospital room and they can't come out and no one else can go in, but there's a window. Could you have the testator sign the will, acknowledge it, right? Hold it up and say, this is my will and this is my signature, and then pass it under the door to the witnesses who might be standing outside the room. I think you could, as long as they can see the person, because the Minnesota cases on this talk about being within the range of the person's vision or within the sound of the person's voice. And those are not and, but or requirements in the case law. We don't have a requirement that they all have to be together at the same time and sign in the presence of the testator and each other. That's the more conservative sort of common law approach. That's not Minnesota's rule. The probate code allows the will to be witnessed within a reasonable time of witnessing the testator sign or acknowledge the signature or acknowledge the will. In fact, there have been cases where the witnesses signed even after the testator had already died. As long as it was in a reasonable time, that counts. So if you can get the testator to sign it and acknowledge it to someone, there isn't any reason why that document couldn't sit around for a few days until whatever germs might be on it have died, and then have the witnesses sign it later. So I think you can space things out a little bit if that's helpful. When I was thinking about this presentation, I initially thought that the will was going to be the most challenging document for clients to sign. I don't want to spoil anything, but I have concluded that I think healthcare directives might even be more challenging to sign. But if you have questions, and I see John Nesserly has already tried this, you can chat them in that chat box, and Adam, our fearless moderator, will read them and bring up the questions if we have time and they're relevant. So do ask questions if you have any. Before I move off of wills, Richard, Denise, anything to add on that?
One thing that we did talk about, Mike, and getting ready for this was the kind of can you have someone witness a will via video, for example? And is that possible?
Well, at this moment in time, I don't believe there's any case law support that counts. you are, yes, in the range of the person's vision, but only electronically. You're not actually able to see the person. For example, we don't know whether there's a person with a gun standing just outside of the camera, right, holding a gun to the person's head. So I think trust and estates lawyers are wise to say, just because there aren't any cases that say it doesn't work, doesn't mean that you should be the one to try and make that law. If your client is close to death and you don't have any other choice, I suppose you can try that. And then once our harmless error statute gets enacted, you might be able to then argue that you did the best you could and we have clear and convincing evidence of testamentary intent. But until we have statutory law that specifically says a video witnessing is the same as witnessing it in person, I wouldn't be the one. I wouldn't want to be the one to try that out. And Denise will tell us in a little bit what clear and convincing evidence means. And if we can't hear her voice, I'll do my best to read her lips and repeat what she's trying to say. Anything else on wills? Okay, trusts are another matter, and in many ways, Minnesota's law on trusts is pretty helpful in this regard. For one thing, Minnesota even permits oral trusts as long as the trust owns tangible personal property. I guess not just tangible personal property, any personal property, so stocks, bonds, and cash as well. If it's going to own real property, the statute of frauds applies, and therefore you have to have it in writing. One of the questions that's come up is whether a will needs to be notarized to be valid in Minnesota, and some people have posited that it doesn't if it's only going to own personal property, but that you might need to have it notarized if it's going to own real property. I think one of the things I can say for sure is that if it's not notarized, you probably can't record it. So if it owns real estate and you had to record the trust instrument, if it isn't notarized, it's probably not recordable. But it's not clear to me that it would be invalid. The statute of frauds requires transfers of real estate in trust to be in writing and subscribed, and then they have to be acknowledged in order to be recordable. So you could say that the deed transferring the real estate into the trust must be notarized in order to be recordable. The trust has to be in writing and signed to satisfy the rules of the statute of frauds. But if you are going to have real estate in the trust, it might not be a bad idea to see if you could get it notarized. If you can't, perhaps consider putting the real estate into an LLC, and then you can transfer the LLC interest. Of course, in order to do that deed into the LLC, you'd have to have a notary. So you may as well just notarize the trust agreement. But trusts don't have any other particular formalities. You simply have to have evidence that the person has the intention to create a trust, and a trustee that has active duties, and a beneficiary, and some sort of property. So the rules for trusts are statutorily governed by Minnesota's Trust Code 501c401. Specifically talks about the methods of creating a trust, and 402 describes the requirements for creating a trust. 407 describes the rules for oral trusts, and just for fun, 408 talks about creating trust for the care of your animals. So if that's what it's come down to for your client, you may need to do that as well. But trusts, in spite of the fact that many forms have witness blanks on them, trusts don't need to be witnessed. They're not wills and therefore not subject to that formality. They can simply be signed and dated, I think, by the person creating the trust. And again, if it's going to own real estate and that's important to you, have it notarized if possible. Let's talk a little bit about that. How do you go about notarizing a document? Actually, we can talk about that in a minute. But there are many different ways to get a document notarized, and we can go through that in a minute. So it may not be impossible to get something notarized. It just might not be easy. Any other comments on trusts, guys? The third one on the big four list is the power of attorney. This one was a surprising in a pleasant way, I think, to me when I looked at this. Minnesota's rules on powers of attorney are in Chapter 523 of Minnesota statutes, and 523.01 talks about the rules for setting up a power of attorney. A competent adult may designate another person or an authorized corporation as their attorney in fact by a written power of attorney. It's validly executed when it's dated and signed by the principal. Period. Dated and signed. So it has to be in writing, has to be dated, and then it has to be signed by the principal. That makes it a valid common law power of attorney. Now, if you want to have use the statutory form, the Minnesota statutes has a statutory short form power of attorney. It's not all that short, but it is a statutory short form power of attorney. That needs to be notarized to be a short form power of attorney. If you sign it and date it, but don't have it notarized, you still have a power of attorney. It's a common law power of attorney. It doesn't benefit from all of the protections of the power of attorney statute, but it is still a valid power of attorney. You could then, when this storm passes, if you need to, re-execute it, right? Have the client sign it again and have their signature notarized. And I think that would generally be a good suggestion if you do things in a panic or sort of with a lick and a promise, as my grandmother would say, in this interim period. When you get a chance in 3-4 months or whatever, sign everything again if you're worried. Better safe than sorry in that example. But I think a power of attorney could be done as long as it's in writing, simply with the signature of the principal and a date. Then you could use that power of attorney to fund a revocable trust, for example. And if you had a trust in existence, you could amend that trust by a writing that was signed and dated by the principal. So if your client already has a trust plus a power of attorney could help you get pretty far down the path to getting a complete set of documents executed, even if you can't get near the client physically. If you don't have the trust already, setting up the trust and then funding it with the power of attorney if the person can't get up and about and move assets themselves would work as well. So the last one of the big four, and probably the one that's on everybody's mind in this healthcare crisis that we're in, is the healthcare directive. That's Chapter 145C of Minnesota statutes. And the requirements for a healthcare directive are in 145C.03. And they require the document to be in writing, dated, and they have to state the principal's name. They have to be signed by the principal with capacity, or by another person who's authorized by the principal to sign on their behalf. And then they have to either be witnessed by 2 witnesses who are competent adults or notarized. The witnesses, there's a little bit of a requirement there. The witnesses cannot be the agent named in the healthcare directive, and neither can the notary be the agent named in the healthcare directive. And only one of the witnesses can be a healthcare provider. So if you've got the case we talked about before, where you've got husband and wife and a child at home, for example, an adult child, they could do a will, but they wouldn't necessarily be able to sign a healthcare directive, even if one of them was a notary, if they were naming each other as agents, because the witnesses wouldn't be valid witnesses. And we don't have this sort of harmless error provision for healthcare directives or powers of attorney. The harmless error statute that I sent out before and that Jolene talked about will only allow you to make the argument that a will should be probated if the testamentary intent is established by clear and convincing evidence. So again, my sense of this after I walked through it all was that for people who are stuck at home and don't have access to witnesses and notaries, a healthcare directive might actually be one of the more challenging documents to get signed. The power of attorney, probably one of the easier ones. A trust, probably the easiest of all, and a will somewhere in the middle. So that background, does anybody else have any questions or any comments on the technical requirements? I think there are cases oh, go ahead.
Well, one question I wanted to touch on related to healthcare directives, I think it's pretty common for when someone enters a hospital or other care setting for them to the healthcare workers to ask if they have a healthcare directive and help them prepare one. So, could you clarify? Can a healthcare provider notarize the healthcare directive? Because it sounds like they wouldn't be able to serve as both the witnesses on a healthcare directive.
That's right. Let me read the statute while you guys talk about something else. I've got it pulled up here and I can look at it. But I have a feeling that they can, because I'm sure that's how they do it, that they notarize them at the hospital.
Yeah.
But I'll verify that while you guys talk about something else.
Well,
is now the time to talk about notarization?
Yeah, I was going to move to that. So we have several states recently have acted remote online notarization statutes, and I understand there is some proposed federal legislation. Minnesota is one of the states that recently enacted the remote online notarization statute. So could you provide some thoughts on how we might be able to use electronic notarization, and then perhaps also touch on how this might interact, if at all, with the electronic signature laws that we have in Minnesota?
Sure.
Whoever wants to take.
Yeah. Remote online notarization, it sounds like it would be the sort of thing that you could do by watching somebody sign on your camera and then taking your notary stamp and applying it, and you've now got a notarized document. It's not that simple, unfortunately. The statute that they adopted that we sometimes call RON, because remote online notarization shortens to RON, requires quite a bit of additional technology and steps. First of all, you have to be registered with the Secretary of State's office. You have to make a record of the notarization. You have to videotape it and record that videotape for a period of time. You have to keep a log of each online notarization that you've performed. And there are many other requirements. You can learn more about it on the Secretary of State's website. They have a frequently asked questions page. And then you can obviously read the statutes as well. I wish I could.
Yeah, that one's. I'll put it in the chat, Michael. I got it here in front of me. So.
Okay, it's somewhere in. Is it 5?
The remote online notaries are actually Chapter 358.
358. Well. You usually can remember statutes. That one I simply couldn't remember. I don't know why. So many firms in town, I think, have looked into getting registered to do remote online notarization, and have simply decided that the technology investment was too much, and that the complications were too great to justify it. The view wasn't worth the climb, so to speak. And so many of us have decided that instead we would try and use a third-party vendor. And there are several of them listed on the Minnesota Secretary of State's website that are able to do this. The two that look like they'll be willing to do it as a fee-for-service, just as a one-off, are Notarized.com and NotaryCam.com. I think based on my look at their website yesterday, they both are under extremely high demand. I think Notarized.com says it's only doing individual notarizations between midnight and 10 a.m. or something like that. And it might take you an hour and a half or 2 hours on the phone to get somebody to be able to do that. But what they do is provide you with an electronically certified notarized document. If the federal statute that goes through, which is being promoted by the Realtors Association, it would allow basically remote online notarization to be recognized in all 50 states, as long as the state statute meets a set of minimum requirements. And essentially it would try and level the field so that you could remotely notarize anything in any state, and that notary stamp would be recognized in every other state. Denise, let's test out the sound here and see. Do you have any reactions to that? Let's see. See if I can hear you. Try it again. Let's see. See if I even have a connection to you. I can't hear you on the phone even. Yes, I can hear you now. Let's try that. Say, try something.
Okay. And I can hear myself too, which is annoying. I'm gonna read that. Okay. So the comment I'd add, I'm gonna talk slow because I realize I'm coming to you through Mike's phone, then back into the session, which is a little bit strange, but had some problems with my technology. One additional comment I made, and I put it also in the chat, firms should check their errors and omissions and their coverage on this too, because there have been instances I've been hearing about where it is addressed in terms of how you do notarization, and if there are problems, you may not have coverage, so you should take a look at that. The other thing I was going to say about the proposed federal legislation is that there is a preemption issue here that's been knocked around a little bit, and I will say that my general sense when I took a look at it is the federal proposed statute is probably going to be irrelevant to us in Minnesota. Our remote online notarization statute is very robust, and it's modeled after the Uniform Act, and it's going to be much more detailed than what I saw in the proposal at the federal level. So it's unlikely that the proposed legislation would be a floor and states would be allowed to go above that. So it's going to be unlikely that the federal legislation is going to have any impact on us. In other words, it won't preempt our current act. So that's what I'd throw in. I hope that worked okay.
Yeah, I heard you great, but my phone is sitting right in front of me, so I don't know if everybody else could hear. Adam, could you hear her? Okay. So if remote notarization could work,
yes.
If you would be able to take advantage of that, I think you could use it to have a client log on. They fill out some biographical information on a web page to verify their identity. Then they get on the video camera with a person on the other end who certifies that they are who they say they are and verifies their signature. That could be a way to do perhaps a power of attorney or a will. But again, we don't know for sure how this is all going to come out. I think with the benefit of our harmless error statute, the will, which doesn't need to be notarized anyway, isn't going to be affected by this. The power of attorney can be valid without being notarized, so that shouldn't be affected by it. So the one thing that you might need to have a notary for would be a deed, I suppose, or the healthcare directive if you can't get two disinterested witnesses involved. So this may or may not be useful, but if it is, I think the state statute caps the fee that they can charge for remote notarization at $25. So your mileage may vary. That may seem cheap to you, or it may seem very expensive. I don't know, but if there's no other way to get a document signed, that might be $25 well spent. Okay, Adam, anything else?
Yeah, I wanted to clarify whether the electronic signature, maybe you touched on this and I was distracted. The electronic signature, I can't think of the name of the statute, it's just 325L. It seems to include a list of documents that you cannot execute under those provisions. Does that prevent us from using from signing a trust electronically and or using the RON for those types of documents?
Well, I think so. I think Chapter 325L talks about the validity of electronic signatures and tries to make electronic signatures the equivalent of what you might call a wet signature, right? An ink on paper signature. But 325L.03, the scope provision, says that it specifically doesn't apply to the healthcare directives, recording any conveyance, powers of attorney, or other instruments affecting real estate, the statutory short form power of attorney, and the creation of healthcare instruction for intrusive mental health procedures. In other words, what it says is those statutes will prevail. If their requirements are stricter, this won't override them. So I think it would be safe to assume that you can't just simply affix an electronic signature to a will, like a DocuSign, sort of where you click something and it treats it as if you signed it. I know people do that for certain kinds of transactions, do it for contracts and things like that all the time. But I don't think that'll necessarily work for a will. Again, distinguish that from taking the Samsung Galaxy tablet and signing your name with a stylus. I don't think that's an electronic signature the same way that this statute is talking about. I think this is talking about DocuSign or some other statutory electronic technology-based method of pushing a button or clicking something in order to have it treated as a signature virtually. Richard, do you have any thoughts
there was
on that?
some questions going on, I think, in terms of the discussion in the chat about utilizing a deed or what qualifies as a wet signature, perhaps for recording purposes. And in Chapter 358, it does have a section that talks about recording electronic documents in tangible form. So, and again, this is all part of the RON, Remote Online Notary section or chapter. So our statute does accommodate or allow the ability to record a deed, I guess, in theory, that was electronically notarized. And there are steps laid out in section 358.646 that would allow that, which again is totally different than just a regular electronic signature that Chapter 325L covers. So I think it comes back to where you started this all, Mike, was what is the document that you're wanting to actually work from? So we have an understanding of what wills should be and what does the law allow, and then we just have to work backwards from there, I think, in terms of what we can do either electronically or not. So.
Thank you. Okay, so just looking at the time, I think we need to kind of switch topics a little bit so we can cover the other things. So the one thing, Richard, I wanted to have you address is what are the different, there's been a number of, I think, executive actions that have moved back tax filing deadlines, both federal and state. So I just wanted to have you give us an idea of what has been moved, what hasn't been moved, and
so it's been busy on the not only is it tax season in general, it's been busy on the changes that have occurred. The latest occurring late yesterday or yesterday afternoon at some point. It's funny, getting ready for this presentation, I checked the IRS FAQ kind of update page just to confirm nothing had changed, and then after I had checked that, then the changes came out. So I think the big takeaway is we have to continue to monitor these things just to obviously stay on top of them. So the latest changes that came out essentially state that if you have and this is on the federal tax side, if you have a federal tax payment obligation that's due between April 1st, 2020 and July 15th, 2020, you have that extension to July 15th to make that payment. And then if you have a federal return that's due during that same time period, April 1, 2020 to July 15, 2020, you're in that extension window, if you will. And so during that time, if you need additional time, if you aren't already under an extension that you might have filed otherwise, then you can go ahead and file an extension. So the most obvious example would be someone needing for their individual return, 2019 return, filing an extension request. They can file that by July 15th, but you'll still need to have your individual return done by October 15th, 2020. So that was just interesting developments that have occurred over the past few weeks on that. Other subtleties within there that were cleaned up, for example, or I should clarify that it covers other returns other than just individual. It can be fiduciary returns, estate tax returns that are due. Earlier on, gift tax returns were included in that extension to July 15th, 2020. So it's definitely has been a moving target, both at the state and the federal level. For Minnesota, has not been as accommodating, if you will. However, if you look at their COVID website, and I have to read the language, highlighted it for them. It basically says, and this would be for business returns. They're saying that payment due dates have not changed. Taxpayers can request relief from late filing or late payment penalties and interest for reasonable cause, including emergency declarations by the President and Governor due to COVID-19. So there isn't as much clarity or movement, I should say, in terms of the deadlines on the Minnesota Department of Revenue side. However, they seem to make it sound like we will work with you on figuring out if there should be a reason to impose a penalty. The other thing I'll note too is penalties and interest are suspended during that April 1, 2020 to July 15, 2020 timeframe. So it's certainly interesting times in terms of what's been affected on the tax side. And I think if you look at the IRS website and start from there, or even search out in terms of different types of situations, it seems to be changing, being updated fairly frequently. So I don't know if I want to pause and take a moment and see if there's any questions, Adam, that you've noted in the chat line, or if Michael or Denise have any other questions.
No. Did you cover
no. So the Minnesota individual returns have been moved. It's the business returns that have not been moved for their filing deadlines. Yes, that includes the trust returns fall under their business definition then.
So 1041 in a Minnesota
would still be due.
Would still be due.
Yeah, unless you get an extent. It's kind of in this, get caught in this circle where you could ask for an extension on the federal side, even though you're technically have that extension through to July 15th, then in which case you would get the Minnesota extension as well too, which is tied to the federal that you've actively filed, I should say, as opposed to just getting by default. So.
Okay. The other thing that we wanted to cover today, and I think Denise was maybe going to cover this topic, so we'll see if we can get her on again, is what impacts have you seen from essentially the courts closing or largely curtailing what you can go to the court for right now? And then we also had a specific question from John Meserly at the beginning of this that I think we should address. But just if you want to just kind of broadly answer that question, and then I'll go back to it.
Okay. Can people hear me?
Yes.
Richard and Adam, you're my sign if people can hear me. Okay. So I will say it's fluid, and it really varies in terms of the various courts. And the type of case generally. So if you have anything that's pending in court, you're going to really need to spend a little time figuring out what the specifics are about your situation. There is some proposed legislation, for example, about tolling statutes, but I don't think anybody should be counting on that. And you should be thinking, if you've got a case that you're thinking about filing, you should proceed as if the statutes are going to hold. The courts are accepting electronic filings. They're just not accepting paper filings anymore. So if you don't know how to do an electronic filing, you're going to have to figure that out. After that, every county has got a little bit of a different procedure in terms of how they're prioritizing cases, what they're hearing, what they're not hearing, how they're hearing them. My general observation, and I also, I would be happy if anybody's got a particular situation and they want to consult for a few minutes. I would be glad to talk to anybody offline about recommendations in different courts. But generally, what the courts did initially is prioritize what they're going to hear and what they're going to give access for. And it seemed like the courts were going to be frozen for a while. That's not my assessment anymore. We are quickly figuring out how to do things in this new world order. My cases have slowed down a bit, but we have just shifted to telephonic hearings. Each one of my cases that I have that's active, that we have status conferences with the judge in order to determine how it's going to proceed, how we want to handle it. So a lot of litigation activity is continuing, if at a little bit of a slow pace, because we're just needing to figure out some of the new procedures. Judges are making themselves available for status conferences and hearings. I think the two things that will be probably delayed for the foreseeable future are trials that aren't already set, and depositions. There's a pretty strong disinclination to doing a deposition remotely if it can be avoided, particularly for lay witnesses. So it's changing. I've quit saying the courts are frozen. Things are starting to move again. But you really need to take a look at the court's website that you're in. Read Judge Gildea's order, and I'll forward it when I get off. I will send a link to that, of March 20th, that was supplemented on the 26th. That gives you a broad overview of how the state courts are handling it and the appellate courts are handling it. And then each county has a little bit more detailed information. Only other thing I'll add is nobody should expect times for appeal to change. If you've got a matter that needs to be appealed, don't count on that changing at all. Once you've got cases, people are being flexible in terms of deadlines, but some of those hard and fast rules about deadlines to appeal, etc., are staying pretty put.
Thank you. So this is a question for the panel: is how are initial new probate filings being treated?
Well, I'll take a crack at that one. I have filed 2 or 3 of them since March 13th, and I've gotten back communications from Laura Stevens in Ramsey County, and got a notice that was published in the paper the other day, but I haven't had anything come back from Hennepin County. So I think, as Denise was saying, it's going to be county by county, and you probably just need to figure out what your county is doing. But it seems that at least in Ramsey County, Laura Stevens has been looking at documents. Has anybody else had any experience? Maybe you can chat one way or the other if you've had any experience that way. But I haven't had any action from a court. I haven't received any new orders or anything like that.
Okay. And when it comes, so in Hennepin County, for example, and this kind of gets to John's, at least a part of John Meserly's question is, if you have a client who needs access to the decedent's assets and you're not getting a response from Hennepin County, is there anything that you can do in that respect? I know the probate code provides some authority for presumptive PR to handle estate assets and make decisions, but I don't know that it's something that would be honored by a bank, for example, or a recording, county recorders.
Yeah, I think you're going to be on the relying on the goodwill of the person. I have one client who's got Excel Energy to change the address for mailing statements to his address instead of the decedent's home address. But I don't know that you'd get a bank to free up funds if you didn't have letters. So I think certain things that aren't going to involve effectively changing ownership to property, but simply changing administrative details, I think they'll probably work with you. And my hunch is that creditors will simply have to wait to get paid, and you should be able to work with them on interest and penalties if you simply don't have access to the money. Also, I think PRs who have liquidity could advance money to pay bills or keep insurance premiums going, for example, if necessary, and then reimburse themselves when they do have access. But if you don't have liquidity, that doesn't do you any good.
Well, I think one of the tip I'd add on that too, and I ran into this last year on a, it's the classic, the family sells the home and then finds out later that they actually have to go through probate to allow the title to be transferred, and so we had to do special administration to make that occur. So if you do faced in a situation with managing assets and need access to them, be specific in the order for the special administration for the types of assets you're wanting to manage, because depending upon who receives those letters, I got pushback, and we had a little bit of a spin around on what exactly a special administration letters mean, and how it works with dealing with real property. So it just added for a little bit more turmoil for the family, because they did need to have access or to close out an estate or an asset, excuse me, the home sale that is. So.
Okay. Well, we've got about 3 minutes left. Is any kind of closing thoughts that you'd like to share in the last few minutes here?
Yeah, Denise, I think you made a good point about getting through this the best you can, and then going back when you have time and sort of doing it right. Some of that we may not be able to bill for, but part of this job is just doing right by our clients, and I think we're all going to have to be understanding about that. But did you have any other, what advice are you giving your internal partners, Denise, about getting documents signed in this age?
So I've been really trying to stress to them that the population we're worried about is that population that is going to lose capacity or pass away in this period of time when we're kind of all in suspended animation. And that's where they should put their focus on making sure that we're minimizing risk there and doing the very best we can and availing yourself of all the sort of guidance that Mike set out at the beginning in terms of options. After that, my advice has been go back and reevaluate and figure out what can be done better. Don't let that slip, because the thing is, we all feel right now like we're in this crazy time and everybody's going to give everybody a little bit of grace. That's maybe feel that way right now, but the documents that are being signed right now for most folks are not going to be looked at again for 10, 15, 20 years. And people are going to forget what it was like during this time, and they're going to be under the scrutiny of the future, not the present. So, make sure that if keep your eye on what's actually important here. Fix what you can afterwards if you've had to be a little bit, creative, and then, we're gonna all change our practices after this, and hopefully the next time that something like this comes around, we're better equipped for it.
Jolene, you came back into the screen. Is there something that you'd like to add?
Can you hear me now?
Or you might be on mute.
Can you hear me? No, I just wanted to take a minute to thank you, Adam and Joel, as chairs of the Education Committee, for getting this organized, for the panelists for speaking, and for everyone on the council who's been working so hard to try and help everybody navigate through this. The amount of time you've put into this is extraordinary, and I really appreciate it. Everyone does. And look forward to possibly doing more of these types of CLEs remotely as these issues continue to come up, because we're all facing unprecedented questions that sometimes it takes a whole village to figure out what the best answer is versus what maybe the right answer is. So I just wanted to thank everybody again.
Yeah, my final word of wisdom, don't share pens.
Well, I think that can